Recently, there was a Campbell Soup executive who was secretly recorded during a meeting, and a lawsuit has now been filed in Michigan's Wayne County Circuit Court, accusing that executive of making disparaging comments regarding the company's customers and employees. I want to go ahead and bring in Stephen Glickman, who is an employment law attorney, to talk a little bit more about this situation that Campbell Soup has found themselves in. Thank you so much for your time. I think you're on mute right now.
Can you hear me now?
I can hear you now. Thank you so much for being here.
Thank you for having me. So this is in employment law what we call a retaliation lawsuit, and the plaintiff is alleging that they were terminated in retaliation for reporting alleged race discrimination. The background is that the employee recorded a conversation with an executive during which the executive allegedly made disparaging comments, race-based, about employees of Indian origin. And subsequently, the plaintiff disclosed and reported that conversation to management, and allegedly then he was terminated 20 days later. So he's claiming retaliation, that he was terminated in retaliation for his protected activity of reporting and opposing alleged employment discrimination on the basis of race. So the law of retaliation, it's a little tricky, but there are three basic elements. It's the plaintiff's burden of proof to establish three things: that the plaintiff engaged in protected activity, which we'll come back to in a second, that the plaintiff was the victim of an adverse employment action, such as a termination, and thirdly, and this is the big one, that a causal connection between the protected activity and the adverse employment action. So when we talk about protected activity, that's simply an employee's act of opposing what the employee reasonably and in good faith believes to be an unlawful employment practice, which can be one of many things: employment discrimination based on a whole host of protected classifications, retaliation itself, harassment based on a host of various protected classifications, sexual harassment, wage violations, so on and so forth. So here the protected activity, what was his report and his opposition to the alleged race discrimination.
Yeah.
The key to all these cases is the plaintiff must establish a causal connection between the two. And that's where the timing comes in, the timing between the alleged protected activity and the adverse employment action. So typically in retaliation cases, the plaintiff's primary evidence, not their only evidence, but their primary evidence, is close temporal proximity between the protected activity and the adverse employment action. Here, allegedly, it was 20 days, which would be considered close temporal proximity. And the courts generally have held, and particularly in our jurisdiction, it's a Michigan case, but in our jurisdiction here in Illinois, the federal courts have consistently held that when there is close temporal proximity between the protected activity and the adverse employment action, coupled with some other suspicious circumstances, that will raise an inference of retaliation. Now, that doesn't mean the plaintiff wins the case outright. That just means the plaintiff has met their burden, to establish a case. Then from there, it goes through the legal process, and ultimately, the question is what the employer's actual subjective motivation was for the termination decision. That gets into a myriad of other evidence regarding the termination decision, the basis for it, and other suspicious circumstances surrounding the termination. When it comes to employment law, it's frequently all about the suspicious circumstances surrounding the employment decision in question, whether it's a termination or a demotion or some other adverse employment action. The courts even use the phrase fishy in their legal opinions. The courts talk about fishy circumstances, and the fishier the circumstances are, the greater the chances are that the plaintiff will prevail.
Yeah,
So,
when you speak of fishy circumstances, just reading over the alleged conversation that was recorded, it says we have stuff. I'm sanitizing it here. We have stuff for poor people. Who buys our stuff? I don't buy Campbell's products barely anymore. This, again, the voice allegedly belonging to this executive. Bioengineered meat. I don't want to eat a piece of chicken that came from a 3D printer. Again, allegedly from this executive. What's different between what you're describing and, say, a whistleblower complaint?
well, whistleblower is very similar, but let me point out that there's another alleged statement that's part of that recording, and that's that the person being recorded allegedly made race-based disparaging
Oh,
statements.
let me go further down. Yes, you are correct.
Yeah.
So he also allegedly made derogatory comments about Indian coworkers. According to the recording, claimed he sometimes came to work under the influence of marijuana. He said an expletive, that they don't know anything, that they couldn't think for themselves. Again, speaking of the Indian community. So, yeah, there are several different aspects to this.
Absolutely. But for purposes of the retaliation claim, nuts and bolts, it's the alleged race-based disparaging derogatory comments about the employees of Indian origin. That's the key, because the plaintiff's reporting of those alleged comments, that's the alleged protected activity.
So would the company have grounds? I mean, let's take, if we took out the race aspect of it, if we took that out, can someone just record their boss secretly? Is that okay? Or would this be a complaint regardless?
To have a valid retaliation claim, the plaintiff must have opposed an unlawful employment practice. So if you remove the alleged unlawful employment practice, which would be the employment discrimination in connection with the alleged statement about the Indian employees, it would be a different story. As far as secretly recording a conversation with one's boss, that's the law there is going to depend on the state. Now here it was Michigan. I'm a Chicago attorney, but I took a look at Michigan law regarding what we call eavesdropping, and Michigan is what we call a one-party state. That means that in a conversation between two participants, one of those two participants may record the conversation without disclosing to the other participant that they're recording without their consent. In two-party states, that's only permissible if the participant who's recording obtains the consent of the other participant. But here in Michigan, where it's a one-party consent state, that is permissible, and consequently, the alleged recording itself could be admissible into evidence in a subsequent lawsuit.
Does it matter how long this man had been working for the company? Because it doesn't seem like he had been working for them for very long before this even happened.
Yeah, legally it doesn't matter. As a practical matter, when it comes to employment law, longevity counts. And when you have a plaintiff employee or a former employee plaintiff, who's worked there for decades, since Reagan was president, or since Carter was president, since Clinton was president, with that longevity coupled with a strong track record of strong performance reviews year after year, decade after decade, that's going to count as a practical matter, and that will lend tremendous support to the plaintiff's case. Whereas if you have an employee who was brand new, it's a different story. It's the opposite. If you have an employee who's only been employed for, say, 3 months, or 4 months, 90 days, and they're terminated, and then they come with a lawsuit. We don't have that track record of decades or at least years of service and loyalty. There's no track record of performance, which is always relevant. And as a practical matter, the sympathies aren't there because the employee wasn't there so long. When it's kind of mid-range, 1 to 5 years, say, it's going to be more or less neutral.
Mm-hmm. So what could the man, Mr. Garza, who filed this complaint, what could he be entitled to if the court finds that he was retaliated against?
The recoverable damages in a retaliatory discharge case under federal law, which is what we call Title VII, and also under Michigan state law, include a whole host of damages, and that includes lost wages and lost benefits, back pay, front pay, lost value of insurance benefits, lost value of retirement benefits, lost bonuses or incentive compensation. Those are all the so-called economic damages, but a prevailing plaintiff in a retaliatory discharge case is also entitled to recover compensatory damages for emotional distress, as well as punitive damages. Compensatory and punitive damages are capped under our federal law at $300,000 for the largest size companies with 500 or more employees, but there is no cap under Michigan law or under Illinois state law for that matter. So there's always the potentiality for a large punitive or compensatory award looming in every case.
Yeah.
And additionally, a plaintiff in these types of cases, if they prevail on some or all of the claims, can recover their reasonable attorney fees and litigation costs.
Mm-hmm.
And that's what we call attorney fee shifting. In employment law, it doesn't go both ways. It's unilateral. So if the plaintiff prevails, they can recover the court awarded their reasonable attorney fees and costs. How that works, this is way down the road after a trial. If there is a trial and the plaintiff wins, then after that, the plaintiff would file with the court what we call a fee petition, and that's a statement of all the attorney fees in tenth of an hour or quarter hour increments from start to finish, which could cover years of litigation.
And so,
But
so this could take years to be resolved?
well, the vast majority of cases, employment and otherwise, settle at some point or other. It's only a minority of cases that don't settle, that go through the entire judicial process and actually go through a jury trial. But
Okay.
you never know.
Yeah.
But for those cases that never settle, yeah, that process takes a long time, depending on the jurisdiction. Easily, well, here in Chicago, in federal court, 2 to 3 years, not counting an appeal. With an appeal to the federal court, to the federal appeals court, 2 to 4 years. In our state court, even longer. So,
Wow.
and that's one of the many reasons that the parties tend to settle at some point or other. Often it's before a lawsuit is filed, but even after a lawsuit is filed, the parties may settle at some juncture or other in the process before an actual trial.
Attorney
But-
Glickman, well, go ahead. Go ahead.
Oh, yeah. But again, back to the fee petition, if we go through the entire process, jury trial, plaintiff wins, then the plaintiff files with the court, the fee petition. The defendant, would file objections to it, and then it's the judge who determines and decides what amount of those fees are reasonable, and costs such as court reporter fees, expert witness fees, filing fees, and the judge makes a ruling and determines a specific award to the plaintiff for a specific amount of fees. It's never going to be 100 cents on the dollar, but it's after years of litigation, that could be a hefty amount.
Well, Attorney Glickman, we certainly appreciate you taking a few moments to kind of talk us through that. Thank you so much for your time.
Oh, thank you for having me. Have a great Thanksgiving.
Happy Thanksgiving to you and yours as well. Thank you. And I do, before we go to break here, I want to let you know that Campbell Soup is on the record saying if the comments were in fact made, they are unacceptable. They do not reflect our values and the culture of our company. We are proud of the food we make, the people who make it, and the high quality ingredients we use. The comments heard on the recording about our food are not only inaccurate, they are patently absurd. The company says that it was not aware of the recording before the lawsuit was filed.